na 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 na. Bamba. Oh na 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 na. Bamba. Oh na 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 na. Bamba. Oh na 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 na. Dig it up. Oh na 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 na. Dig it up. Oh na 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 na. Bamba. Bamba 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 de. Bamba bamba. Bamba mi de. Bamba 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 mi de. Bamba bamba. Bamba 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 de.
Good day, everyone. Welcome to Home and Away Jamaica, where we connect Jamaica with the diaspora. I am Robert Taylor of Taylor Law, and today I have with me Mrs. Stacey Salmons. Stacey is close and dear to us. Stacey is the managing partner at Taylor Law, and we're very glad to have her here today. Stacey is actually the person who executes. So those days I'm here presenting, Stacey is in the background doing and managing many of our transactions. So we thought it would be very opportune today to have Stacey come on the show, join us and explain and talk us through one of the very important areas that we find a lot of interest with many of our clients who live outside of Jamaica, and it's the area of first registration. And by that I mean where land is owned and not owned by way of a registered title. So Stacey will take us through some of the steps to bring land to what we call first registration. Stacey, welcome.
Thank you, Robert. Good to be here.
Stacey, before we go into the subject area, can you just very briefly tell our viewers a little about your background and your specialization with Taylor Law?
Okay, sure. So as you mentioned, I'm the managing partner at Taylor Law. I head the conveyancing and probate department at the firm. So all things to do with real estate, and if clients have estates that they need to wind up, you would come to me and I would take you through that process so you can proceed with your sale, your purchase, winding up your estate. Prior to joining Taylor Law, I spent about 5 years as an attorney at the titles office. My role at the titles office, I vetted applications for first registration, adverse possession, applications for strata titles, lost title applications, and so forth.
Well, that's good. So Stacey, you seem very uniquely positioned to guide us through this morning on the process of bringing unregistered title to registered title. So maybe you can start by telling our viewers or listeners on the circumstances that you generally encounter that result in unregistered title, and maybe how pervasive it is.
All right, well, we have a lot of clients that come to us. They have property without a title and they want to sell that property, but purchasers often want to ensure that they have some kind of security in purchasing the land. And one of the important criteria of securing ownership is to transfer your land by way of title. The title is an easy way to establish ownership because it's a public record that's maintained by the government via the titles office. Also, it's an easy way to transfer title to a third party because you only have to show the buyer that you have the title in your name, and that's all you need to prove ownership.
So Stacey, what I sense you're saying, and we understand from the importance of having title, is that for wealth creation, we need to establish ownership of our property. If we're going to leverage, we're going to borrow against property, or we're going to sell to extract value, it's important that we have a registered title. Banks, mortgage companies won't lend on, you know, what's probably traditional, the deed or some record.
That's correct.
So tell us, when someone comes to you and they explain to you that there's family land, perhaps land that has been passed on from one generation to another. They now wish to sell this property, but they have no registered title. What are the checklist of questions that you'll take a client through in embarking on this process?
All right, so the first thing that I would have the client establish is, what is their claim to ownership? What documentary proof do they have to establish that they own the property? Did they obtain it by way of a purchase? If so, I need them to provide the stamped transfer and the stamped agreement for sale, along with whatever receipts that they may have, together with if it was a sale, if they obtained it by way of a will, I'd ask them to provide the grant of probate with a copy of the will, so I can establish the transfer from the estate to them.
What happens in an instance where, and in this instance, family land, where let's say a grandfather or father may have left land and there's no will, there was no sale, so no evidence by way of an agreement for sale, but persons within the community know that this land has been in the family for at least a generation. How do you manage those situations?
All right, so the application is supported by several documents. So the first supporting document is the statutory declaration of the applicant. So the applicant would set out how it is that he became the owner of the land. The supporting declarations come from two other independent persons who have known the land for 30 years, at least 30 years, and can corroborate the history of ownership of the land, establish that the applicant is the true and rightful owner.
Now, are these declarations done simply in writing? Is there a standard form? How are these declarations done?
All right, so we prepare the declarations after taking instructions from the client. The client would provide us with the name, the contact number of the supporting declarants. We will reach out to them and they would give us the history of how they're familiar with the land and the history as to the ownership of the land. We would prepare the statutory declaration on their behalf and have them come in, sign, and it must be witnessed by a JP.
Now, what I understand you to be saying is that what the law is trying to do is certainly eliminate instances of fraud where persons are incorrectly claiming land that's not rightfully theirs. So what the authorities want to see is proper and complete chain of ownership. Now, suppose someone has been paying the property taxes, suppose there's water connected, light connected. How does that help the process?
Well, paying the property taxes and utilities in and of itself is not sufficient to claim ownership. So it's taken together with everything. The registrar will look at the whole picture to see whether or not the applicant has a valid claim of ownership. So another supporting document that is required in the application is an up-to-date certificate of payment of taxes. So the registrar will want to see that there are no outstanding property taxes on the land. Your application will not be approved without the property taxes being up to date. The utilities, the The utility bills can also support your claim of ownership. If you can provide receipts for payment of water, electricity, any other utilities associated with the property, this will strengthen your application in terms of your claim to ownership.
Are any notices sent to the world at large, so to speak, to determine if someone else has a claim on the land?
All right, so once your application is compiled and ready to submit to the titles office, it's the application, the statutory declarations, the up-to-date property tax receipts, your survey plan, your valuation. Once that's submitted, the referee of titles vets your application. The referee of titles is an independent attorney who vets the application to ensure that your claim is valid. So if it is that once he vets your application, if he views your application as valid, he provisionally approve your application and direct the applicant to advertise the notice in either the Daily Gleaner, well, the Gleaner or the Daily Observer. He'll ask you to advertise for 2 consecutive weeks. So what this notice does, it gives the public at large notice that you are applying to have this parcel of land registered in your name.
Now, you mentioned another document. You mentioned a survey. Explain to our viewers the purpose of the survey and the importance of having a survey.
All right, the importance of having the survey done is that it delineates the boundaries of the land, and it's a mandatory document to support your application. So once a title is issued, your survey plan will be annexed to your title, and that establishes the boundaries to the land.
So what you're saying then, in an instance where there was no title, there needs to be a process where the actual boundaries of the land that you're claiming and the land that you're applying for title to be established.
That's correct.
The way to go about this is retaining a licensed land surveyor who, with certainly your advice and direction, would be able to identify the appropriate boundaries so that the land can be marked for surveying.
Right, and it's also important to know that the survey that you're going to submit to the titles office is not to be more than 7 years old, because the boundaries could have changed between now and 7 years from now. If it is that if you do have a survey that's more than 7 years old, the same surveyor who did the plan has to prepare a declaration just to state that the boundaries are the same as when the survey was originally done. Otherwise, you have to have a new survey prepared.
Good. So let's go through a checklist. I have unregistered land that's been in the family. I come to you. You're going to take me through a number of things that I need to have done. So I'm going to need to have a declaration from persons within the community who can establish and provide evidence that the particular parcel that I am applying to bring to first registration has been in the family or to my benefit for at least 30 years.
Correct.
I'm going to have to retain a surveyor to have the land surveyed and have a survey identification report. I'm going to have to make sure that the property taxes are paid up to date. If there is any utility connection, light and water, I would provide those bills of proof of payment as supporting evidence. You're saying in of itself, these are not particulars that can stand on their own. They must form part of the entire package. Now, what are some of the costs, the statutory costs involved? You don't have to give us to the dollar, but is this an expensive enterprise?
All right, why it's important to have a valuation report done is for the purpose of your registration fees to the titles office. So upon presenting your application to the titles office, your registration fee is 1% of the market value of the property.
So we need to add a valuation to our checklist.
That's right. In the application, it's also a requirement for you to state what the market value of the property is. So the application upon presentation is 1% of the market value of the property. If your application is provisionally approved, you will have to advertise the notice issued by the referee in the newspaper. That is roughly $7,000 to $8,000. Once your ad runs in the paper, you're required to present the tear sheets that contains a notice back to the titles office. And at that point, you pay your final fees for the titles office to prepare your new title. And that's another 1% of the market value.
You mentioned tear sheet. Is that, as the name suggests, that you're tearing the ad out?
Out of the newspaper, right.
Stacey, this seems like it can be an involved process, getting all the documentation in place, getting the declarations, submitting the application. Let's assume that the package, a client comes to you and presents a complete package. Generally, how long can this process take from submission to the time the referee makes that provisional approval?
All right, the application typically takes between 6 to 9 months, and that's including from the very initial stage of submitting your application to the titles office to provisional approval, running the ads, and having your title created at the final stage of the process.
Well, that's good to know. Speak to us very briefly about LAMP and the role that LAMP has in bringing titles to first registration or unregistered land to first registration.
All right, LAMP is it's integral and beneficial to submit your application for first registration through LAMP. LAMP offers several benefits in that there's certain statutory duties that are waived if you go through LAMP. So transfer tax, stamp duty would be waived on your application if it is that you do go through the LAMP program. And typically the process at LAMP can potentially shorten the application time.
Well, in another program, we can speak more about LAMP.
Sure.
And, Stacey, what I think would also be good for us to speak about in another program, having, we're very close to the time, is looking at alternate ways of establishing title where we are unable to provide a full suite of evidential particulars. And by that, I mean adverse possession.
Right.
And I think that's something we can look at in another program where we're not able to establish all the requisite evidence that the titles office may need. Then we may look at going another route, and that route is adverse possession.
Right.
Well, thank you, Stacey. Thanks for coming, and thanks for sharing with our viewers and listeners the process for bringing unregistered land into registration, the process by which you get a registered title. Thanks. Bye for now from all of us at Home and Away Jamaica. Thanks, Stacey. Good to have you.
Thanks for having me.
Bam, bam.